So I simply typed in exclusive equity jurisprudence, and a bunch of videos came up. And I thought this is a very interesting video. This is from IsraelTheSuns. Go check out his channel. Let's just get right into the video.
Mr. Richard Arterburn's case.
Oh, yes.
Cases.
Are you there,
Miss Elsie Craven?
Ms. Craven, are you with us?
Yes, Your Honor, I'm present.
And there's Mr. Arterburn, too.
There she said,
hello,
I'm
Your
present.
Honor. How are you doing?
I am well, thank you. And I don't know how much and how recently you have talked with your lawyer, but somewhere along the way, and I'm talking probably a couple months ago, that you might not be competent to stand trial, meaning that you didn't.
So this is what's interesting. They get all the way to equity court, right? They got all the way to the chancery court, and the judge still try to pull the competent to stand trial situation while they're in equity court.
Have a clear understanding of the charges and the roles of the people in the court and your rights. But I don't know. I don't have any personal knowledge of that. Do you have an opinion about that, sir?
Sir, my name is on special deposit with the court for future return on my interest. I reserve all my rights and remedies, and I waive none ever. I am the beneficiary of this case today. Does the court have any evidence that I am not the beneficiary?
I don't have any evidence at all. We're not having an evidentiary hearing.
Then, for and on the record, the court admits I am the beneficiary, and as beneficiary, I appoint the court as trustee to settle this matter.
Well, I'm not agreeing to that appointment, but again, I am obligated under the law to be sure you're competent. You sound lucid. I would assume that you understand how our system works, even if you don't believe you should be subject to that system. Am I correct?
Yes, sir. I do understand that how your system works, but if the court believes I am the surety, I demand my rights to subrogation and all of the collateral securities. I would appreciate a check by the end of today.
Well, no, I'm not going to agree to that today or any day. But the reason I'm asking you about this, sir, is because if there is a concern that you're not competent to stand trial, and you may end up going to trial against your wishes, and you may, if you choose, voluntarily absent yourself from that trial. Nevertheless, you could end up being under the jurisdiction of the result of the case. Do you understand?
This judge is in extreme dishonor right now. Extreme dishonor. But that's because his ass is on the line.
Sir, I am never under the jurisdiction of the court, seeing as I am the beneficiary.
Okay. Well, we're going to differ, I guess, and I don't know what else to tell you about that. But the reason I'm telling you this, if there is a concern on anyone's part, and I'm going to tell you honestly, after talking with you, except for your belief that you're not subject to the jurisdiction of this court, as is usual in cases like this, I think you are competent. Unless the prosecutor or the defense attorney or anyone else tells me that they don't believe you are competent, I'm going to believe that you are competent. The reason I bring that up is because if it should happen that someone believes that you're...
All right. This sounds like he might try to bounce it back down to them, which means that what he probably did is appeal whatever decision it was, or they try to say he's not competent. I don't know the particulars of how he got into the chancery court, but I would assume, which I could be wrong, but I would assume that he was found guilty and everything that he did, they tried to deem him that he was incompetent. He didn't know what he was talking about. But in the appeal, when you go into the appeal, you get to choose the mode of the court because now you're in exclusive equity jurisprudence, and you're going to go under exclusive equity jurisprudence. This is what he's doing. He put a special deposit in. I did this in Pennsylvania. It definitely influenced the outcome of the case. Whether I got all the way, I didn't go to the Supreme Court or anything like that. The wear and tear of my automobile back and forth to Pennsylvania, I just couldn't do it. It ran my car into the loan upside down. So they'll just milk you and milk you. They might just try to bow to you all the way, but you're not going to go to jail. You're not going to, nothing's probably going to happen. Let's keep going.
incompetent, you will need to be examined, and you'll need to submit yourself to an examination by a doctor. And I'm hoping that you will agree to submit to that examination should it happen. Now, if it's not going to happen, we're all good, and then we'll deal with our other conflicts later, right? But if there's a concern that you're not competent and you refuse to submit,
See, now they want to make sure that he's competent enough and knows what he's talking. They know he knows what he's talking about. They want to make it a competency thing, or that someone question the competency. So they're going to want him to get a whole psych eval and this and that. And the judge, he's going to be able to have the judge say that, because the judge said it on the record that he believes already, even the judge believes that he's lucid and that he's competent. So competency is not really going to be able to be in question at this point. So let's see how it goes.
do an examination. I hate to do it, but you'll be taken into custody and you'll be held in custody until you do submit to an examination in jail.
That's a scare tactic.
I understand what you're claiming, sir. I do not consent to any of that. And
I don't blame you.
and I am
He's being cool with him,
once again,
but he's really being dishonorable.
Jason Steen's the prosecutor. He has no evidence for any of these things. He had no evidence to file the motion. There is no witness in the matter of me for his claim. So how can he make that claim?
I have no idea. I don't know anything that he knows that I don't know. It's just under the law, if either party or any party believes there's a concern about competence, I'm just required to inquire into it. But again, go ahead, Ms. Craven.
May I say something, Your Honor?
Yes.
This
I
judge
was
is not trying to
appointed,
touch this.
To
He's not trying
represent
to touch the
Mr.
case.
Arterburn, and it was a mental health appointment. Mr. Arterburn has not engaged with me at all. I have tried on a number of occasions to talk to him about his case. I have a concern about competency.
It's their case.
Because I was appointed as a mental health attorney, and he was identified as possibly having a mental health problem, and I do not feel comfortable going forward if a client could possibly be incompetent.
Mr. Arterburn?
They're trying so
Yes,
hard.
sir.
To the extent you're willing to tell me, do you have a job, sir?
They're trying so hard.
Do I have a
So now
job?
they're
Because
trying
of
to get.
COVID, I'm currently unemployed, but I have been previously employed since I was 16 years old.
No, see now they're
What were
going to try
you
to
most
gain.
recently doing
They're
full
going to try to
time?
gain counsel.
Door-to-door sales?
Okay. How long did you do that?
No, they're trying to
over a
gain
year.
competency through
Did
saying
you ever
he
get
was employed.
sideways with anybody along the way there while you were doing door-to-door sales?
No, sir.
Okay. Well, I'm going to...
And I object to what Miss Craven said right there. I do not need an attorney, nor can the court force me to have an attorney. I am myself. I am the beneficiary.
You are exactly right. You have a right to represent yourself.
I do not represent myself. It is impossible for me to represent myself, sir. I am myself.
That's just the term of art in these criminal cases.
Yeah, it's a term of
you're
art
pro
in these
se.
criminal cases.
Course.
This is word art.
I'm well aware.
not
I'm well
pro se.
aware of the legalese, sir. It's impossible for me to represent myself, seeing as I am the beneficiary. I'm myself.
So what that tells me is that when we do put your case on the trial docket, in the event that you don't come up with a plea bargain and the state does not dismiss the charge, you will be in the courtroom speaking for yourself.
Now,
I will have
judge
Ms.
is
Craven on the
extremely
side in case you
dishonorable.
should happen to have any legal questions, but she will not at all interfere in the case unless you ask her to. Do you understand?
No, sir. I object. I do not need an attorney. It is impossible for me to represent myself. It is impossible for me to be pro se. The
times.
court cannot force
They're
me
gonna
to be
test him
pro
3
se.
times.
I am myself.
They're
I
gonna
am the
test him 3
beneficiary.
times.
Well, we'll see how that all shakes out, but we're not going to have a trial unless you decide to have a trial, before the court, meaning a non-jury trial, and we do it via Zoom. It's going to be some months before we end up with a jury trial in the courtroom.
So,
Okay.
So I trust that he is competent, Ms. Craven. I'm going to make that independent
I bet you this
judgment.
case never comes
All
up
right,
again
I
after
just
this.
want the court to be aware of my concern
think it's
and that I would request the the evaluation for competence.
He
And if
didn't
the
let him
court
get in.
is finding him competent, then I'm okay with that, sir.
The judge already
The
said
problem
it.
I has is that I don't think he's going to submit to an examination, and I think it will be too oppressive to throw him in jail until he does submit. So I'm just not going to do that.
See?
So, Mr. Arterburn,
He's not gonna do
we're going to
anything.
put your case on a trial dock probably sometime in the fall. Be mindful of that date. We will want you to appear in court for that. If for some reason
Look,
we're still not having
no
in
mental
court,
health
in court,
evaluation.
court, we'll let you know, and we'll do it again as we're doing today. Do you understand? And we'll talk about it.
Yes, sir, I do.
But the case won't go
All right.
forward.
Anything else you want to say or put on the record, Mr. Atterburn?
Yes, sir. A couple things.
He's making it sound like he's
just
still
for
in
the
charge,
third
but he's
time,
not.
I do object to the court trying to force me to have an attorney. I do not need an attorney. I am myself. I am the beneficiary. It is impossible for me to represent myself. And I understand that I am to accurately state the facts. And if I inaccurately state the facts, I may be subject to penalties of perjury under the laws of the United States of America. Having qualified my testimony as in the affidavit that I have filed here today, I hereby state for the record that everything in my affidavit is the truth, the whole truth, and nothing but the truth. So help me God.
Okay. Now you have a right to remain silent, and you can choose to remain silent, and it's your right, and no one's going to complain about that. Or you're free to speak when the time comes.
After what he just
So,
said.
anything else,
He
Mr.
just closed it
Arterburn?
out.
No, sir, Your Honor. I appreciate you. Thank you.
So the way we're going to do it is, Ms. Craven will be in the courtroom. The jury will not know that she's your lawyer, but we're going to have her there just because the law kind of requires us to be cautious. But you will not have to have any communication with her nor call on her for any purpose. Do you understand?
Yes, sir, I do understand, but she does not even need to be there, sir. I do not need her there at all. There is no reason for her to be there. She is not there to. I am not pro se. The court cannot force me to be pro se. I myself, I am the beneficiary. It is impossible for me to represent myself.
May I say something, Your Honor?
Yes, ma'am.
He stuck with his gun.
Ms. Aton with the county attorney's office has put a statement out on the chat saying that this is a court 7 case. If it's not going to remain on the mental health docket, then perhaps the county attorney will want to be setting it back into court 7. I just wanted to draw your attention to that.
I had forgotten about that. And Mr.
Yes, sir.
Arterburn, although I might find this case very interesting and
They're
kind
gonna
of look
send it
forward
back.
to dealing with it in the courtroom, this case is not from my court, so it will be transferred to County Court 7.
Understandable, sir. Understandable.
That is Judge
Well-
Elizabeth Earl, so my coordinator will communicate with the coordinator from that court, and they'll put you on the docket there.
Yeah, they put it on the
Yes,
docket.
sir.
Already assigned to court 7,
They're
Judge.
either- yeah.
So I'll just
See, he's pushing it
email
all the
court
way
7,
out
let
of his
them know that
court.
they
When
need
it
to
gets
set
down
on
to
a
the
jury
lower
trial
court,
docket.
they're gonna be like, "We're not."
Okay.
Oh shit!
Your Honor,
They bounced
may I
it back
interject?
down from above.
Yes.
Oh, it's done.
Sarah Kuhn for the state judge.
Let me back it up a little bit because I was
Case
talking.
very interesting, and kind of look forward to dealing with it in the courtroom. This case is not from my court, so it will be transferred to County Court 7.
Understandable, sir. Understandable.
That is Judge
Well-
Elizabeth Earl, so my coordinator will communicate with the coordinator from that court, and they'll put you on the docket there.
Yes, sir.
Already assigned to court 7, Judge. So I'll just email court 7, let them know that they need to set it on a jury trial docket.
Okay?
Your Honor, may I interject?
Thank you.
Yes.
Sarah Kuhn for the state judge. I just want to put for the record, Judge, that the state echoes defense Elsie Craven's concerns about competency. Your Honor, I believe that a motion and an order has already been signed for a competency eval in this case,
Yeah,
Judge.
they're bugging. He tried to kick.
I think the state will.
So look, he pushed it out of his court and sent it to another court because he didn't want to touch it. He sent it back down to other lower courts. So now the lower courts, they don't have nothing to stand on, and since the ones up above won't deal with it, they bounced it back down. Now this dude's like, oh damn, all they got is to try to do that because they're done. They can't do nothing about it. Let's this interested to see what happens with this.
Obviously follow whatever findings that you have, Judge, if you believe he's competent. But I think the state's position is that given that current motion and order.
So basically, they're all trying to say, "Oh, Judge, even though you think he's competent, we still have questions." That's because they This is funny.
For Judge that
That's all they got.
Mr. Arterburn should
That's
submit
all they
himself
got.
to a competency evaluation before we do anything else on this case. And if he doesn't want to submit to it out in the community, then Judge, I think the warrant should be issued so that in custody examination can be done. Judge, at this time, I don't think the state is
They're going hard.
entertaining any disposition related to dismissal. And because of that, with the ongoing competency concerns, Judge, I think the state's position is that an evaluation should be done before we set it on a trial setting, Judge.
On the record now, I'm voiding the order for an examination. I don't know what paperwork someone will need to send me for that, if any. Mr. Arterburn, I am not going to order that. However, you need to understand that Judge Earl may choose to do whatever she chooses with your case. So I wish you well.
He wishes
Thank you,
well.
Your Honor. You have a good day.
Thank you, Judge.
Thank you, Mr. Ewing.
He ain't want no smoke. He wanted no smoke. He bounced it out of his court and didn't want no smoke, and he's not ordering the psyche valve. They're never going to get this case. That was a good ending.